This is Dave at TitleSearch.com. Let's take a look at what is actually on a property deed. There's certain elements on a document that's recorded called a property deed. The first is there will be indications of the grantor and grantee. Those are the parties that are conveying property rights. The grantor typically is conveying away property rights. The grantee is receiving the property rights. On a typical deed, such as a warranty deed, the buyer is the grantee, the seller is the grantor. There may be exceptions to that. And another section on the deed, there will be a book and page. That will literally be the document recording location in the land records, what book it's in, what page it's on. That necessarily does not correspond to the address of the property. All the documents for that piece of real estate are not in the same book. It goes by date. There will be a legal description of the property that will identify which property is being referenced in that deed, what property is being transferred. It is normally not enough to put a property address or even a parcel number. The legal description is usually a 1 or 2 paragraph long recital of the boundaries of a property or the block and lot number. Now, that way it's very specific to which property is being referred to. There's no ambiguity of an address which could cover 2 properties. There's also different types of deeds. At the very top it may say warranty deed, sheriff's deed, quitclaim deed. Each one has its own level of priority of what rights are being transferred or not, or being retained. Underneath the description of the property or the conveyance, there'll be a section for signatures. Real estate conveyances and transfers are required to be in writing under the statute of frauds. So there will be a section for the grantor at least to sign away the rights. The grantee may not have to sign. In any event, there may be a space for witnesses or notaries to that transaction to make sure that the grantor is identified properly as the person who's supposed to be selling the property. So witnesses and notaries are important to make sure that the notary stamp is accurate, the notary commission is up to date, hasn't been expired. There's another interesting little section on a deed that's called the return to block. It's usually in the upper left hand corner. Once that deed is recorded, it's returned to some party, sometimes directly to the buyer, so they have a copy of their deed. In many cases, it goes to the title company or law firm which handle that transaction. That's important information as you're looking at a transaction or looking at a conveyance to see who handled it, and maybe there may be more information available from that party. And the last most important and often overlooked section of a deed is conditional language. Within the transfer recital, it may talk about remainder interest, meaning that the grantor sells a property but retains certain items. For example, mineral rights. It may retain rights to lease the property. There's also a type of a deed which will retain a life estate, meaning that the property is conveyed to this person for them to use as long as their natural life. When they become deceased, it reverts back to the grantor or maybe even goes to a third party. In a lot of deeds, there's also cross-references that says, please see language in deed in document number 1234, or please see the legal description in document number 85. Those cross-references are important to note because they affect the status of that deed and what's meant by the language in that deed. So it's usually not enough to look at grantor and grantee. You really have to go through and find out all the information to make sure that the property status is understood as it's been described in that deed.